Hey, what's up, guys? This is the Conditions Report, number 29, Shielded by Sovereignty, Federal Authority, and the Hidden Cost of Local Impunity. In this episode, we're going to examine Hamdi Weyker, decided by the 8th Circuit on July 23, 2025. St. Paul police officer Heather Weyker, cross-deputized as a special deputy United States Marshal, was assigned to a federal sex-trafficking task force, or a human trafficking task force, when a federal witness contacted her from Nashville after a physical altercation involving Hamdi Mohamud. Weyker conveyed information to a Minneapolis police officer that led to Mohamud's arrest for witness tampering. Mohamud spent approximately 25 months in pretrial detention before the charges were eventually dismissed. She brought suit under 42 U.S.C. 1983, alleging constitutional violations arising from the statements made. The 8th Circuit held that Weyker's conduct was not action under the color of state law for the purpose of 1983 because it occurred in the performance of her federal task force duties. The court affirmed summary judgment for Weyker and the denial of discovery and leave to amend as futile. The case matters to policing because cross-deputized officers now operate routinely in joint task forces and state task forces, addressing trafficking, immigration enforcement, and violent crime, and it draws a sharp line on when local officers fall outside the reach of 1983 liability. The constitutional stakes turn on the threshold question of state action. The ruling also invites sober reflection on how internal affairs processes can sometimes focus more on a perceived dissent or minor misconduct than viable misconduct itself, and the responsibility of command staff to root out real misconduct rather than expend leadership capital and frivolous energy on low-level matters like protecting speech, secondary employment, or minor policy violations. Have you ever wondered, in the quiet after a long shift, why the machinery of accountability so often turns the sharpest eye to the smallest violation while the larger failures seem to pass unnoticed?
Whether you wear a badge or not, if you care about courage, clarity, discipline, and the price of decisions in the moment that define lives, you've come to the right place. This is where training meets consequence, where the law collides with human behavior, and the fog of uncertainty tests the limits of reason. These are the stories of pressure, of purpose, and what it means to hold the line when the world loses balance. I'm Don, police officer, instructor, and founder of Forecast Securities Group, and I'll be your guide through the storm. Welcome to the Conditions Report.
Again, I'm Don. This is the Conditions Report. If you've already been listening to the show, well, then you know the premise. And if you're new here, well, here's what you need to know. This is the weather forecast for street cops, detectives, and admin, what's coming, what's changing in the environment that we all work in. And before we go any further, here's a quick disclaimer. I'm not an attorney, and nothing discussed on this show is legal advice. I'm not speaking on behalf of any government, agency, or law enforcement agency, and the views expressed here are those of Forecast Securities Group and myself, and they are for sure a protected American free speech. If you need legal advice or guidance specific to your agency or jurisdiction, you should consult legal counsel. This podcast is for educational purposes only. We're not here to judge the officers involved in the incidences or to second-guess their decisions with the benefit of hindsight. The point is to learn from their hard-earned lessons on our behalf and improve as a team. Here's the situation brief. There is a peculiar tragedy in the way the human heart can be both protector and destroyer at the same moment. The story of Heather Weyker and Hamdi Mohamud unfolds like a Dostoevskian parable of good intentions colliding with human suffering. The federal sex trafficking investigation began in mid-2010. Weyker, a St. Paul police officer, was cross-deputized as a special deputy United States Marshal and embedded with a multi-agency task force supervised by federal prosecutors and agents from the FBI and other bureaus. The investigation targeted an alleged interstate trafficking ring and eventually produced dozens of arrests, but no convictions. The specific events that gave rise to this lawsuit occurred one night in Nashville. A federal witness named Muna Abdul-Qadir became involved in a physical altercation with several other women, among them a teenager named Hamdi Mohamud. During this altercation, a windshield was smashed and there was pretty significant violence. Abdul-Qadir called Weyker. Weyker, acting in a federal task force capacity, contacted Officer Beeks, the Minneapolis police officer on the scene. She identified herself as both a St. Paul police officer and a joint task force member. She told Beeks that Abdul-Qadir was an important federal witness and that the other women, including Mohamud, had come to intimidate her, and she spoke of, quote, information and documentation, unquote, supporting the claim of intimidation. According to the record, accepted for the purposes of the appeal, the first part was true. Abdul Qadir was indeed a federal witness. The rest was not. No such information or documentation had ever existed. No credible threat had ever been established by any legitimate inquiry. Relying on Weyker's representation, Officer Beeks arrested Mohamud and the other witness for tampering. Weyker later submitted an affidavit in support of federal charges, again noting her dual role as a, quote, FBI task force officer / a St. Paul, Minnesota police officer, unquote. The charges lingered. Mohamud spent approximately 25 months in custody before the government dismissed the case without ever bringing it to trial, and the prosecution simply ended. No jury heard the evidence, no verdict was returned, and the young woman walked out of custody with the case against her closed. But the months of confinement had already exacted a toll. Public court records and reporting showed the broader federal investigation generated dozens of arrests, but ultimately produced no convictions. Multiple civil suits would follow, alleging that Weyker made false statements and influenced arrests while acting in her federal task force role. The Eighth Circuit and related decisions describe the investigation as deeply troubled. The civil suits largely failed because the courts held that the challenged conduct was attributable to federal rather than state authority for 1983 purposes. Public records indicate that now Sergeant Heather Weyker remains a St. Paul police officer assigned to investigations. She was placed on administrative leave in 2016 after a federal judge questioned statements that she made during a detention hearing. But she returned to full duty shortly thereafter, and no public record of formal discipline or termination related to the task force investigation has been located. And you know the rest of the story because we've all lived this. A task force forms and the paperwork is signed. The deputation is granted, and the officer who begins that day as a local detective steps into a federal role with very clear lines of authority. And anybody who's ever worked in this position, myself included, knows that there's no confusion here. Like, it's very clear what we can and cannot do. There's no illusion about which sovereign power is being exercised. Mohamud turned to federal courts. She filed a suit under 42 U.S.C. 1983, asserting that Weyker's statement had deprived her of liberty without due process. She also pursued a Bivens claim to cover any purely federal dimension of the conduct. The litigation formed as part of a longer series of civil rights actions which arose from the same task force's operation. And earlier, the Eighth Circuit decision had already concluded that Weyker's work on the federal investigation placed her actions directly outside the reach of any state authority for 1983 purposes. And when Mohamud sought limited discovery and leave to amend her complaint with additional details about Weyker's history with Abdul Qadir and the precise circumstances of the call, the district court denied both requests. The court concluded that further factual development would not alter the legal analysis. On appeal, the Eighth Circuit agreed. The panel held that the material facts were undisputed, that Weyker had been acting in a federal capacity when she responded to the federal witness and influenced the local arrest. The state law had nothing to do with the nature and circumstances of her conduct, and the court affirmed summary judgment for Weyker and found that additional discovery and amendments would have been futile. The current conditions are this. Section 1983 reaches persons acting under the color of state law who deprive others of federal constitutional rights. The phrase is not a mere formality. It marks a boundary between the conduct that federal courts will review through civil rights liability and the conduct that belongs to another sovereign. In Mohamud v. Weyker, the Eighth Circuit confronted the modern reality of local officers who are cross-deputized to federal task forces. The court reaffirmed that the focus remains on the nature and circumstances of specific conduct at the issue. Here, Weyker's actions, responding to a federal witness, contacting a local police officer to protect that witness, and providing an affidavit in support of federal charges, occurred squarely within the performance of her federal duties. The investigation itself was federal in character, supervised by federal prosecutors and agents, and directed at an interstate trafficking ring. Even though Weyker remained a St. Paul police officer, the court held that her conduct was not attributable to the state for the purposes of the claim. The decision aligns with earlier rulings in the same circuit and underscores a broader principle. When federal authority is the source of power being exercised, 1983 does not supply a remedy against officers in their individual capacity. The holding carried immediate practical weight for officers and supervisors engaged in these types of task forces. Task force investigations targeting human trafficking, immigration enforcement, and violent crime frequently blend federal and local personnel. The same officer may wear a local uniform one day and operate under a federal deputation the very next. Mohammed v. Weyker clarified that legal character of the conduct, not the badge on the chest, determines whether the claim applies. This case did not turn on something like heck bar or favorable termination doctrine. The dispositive issue was the threshold question of state action, where federal conduct is at issue. A plaintiff may need to consider whether a Bivens remedy is available, recognizing that Bivens is limited and often unavailable in new contexts. Where state conduct is at issue, 1983 remains the proper vehicle. That line is not always easy to draw in the field, but the law demands that precision in the courtroom. Let me speak plainly for a moment. Oftentimes, when departments engage in accountability actions, let's say internal affairs investigations, those often target the low-lying fruit. They often target the minor misconduct, speeding, or maybe you get into a crash, or secondary employment, or speech that they don't agree with, while they completely undermine and ignore the much larger and egregious misconduct that we have all seen. Criminal behavior, immoral behavior, unconstitutional behavior, or just plain incompetence. And those were often swept under the rug because the departments can't stomach the liability of facing the public with those big mistakes. Instead, they punish publicly and hold quote unquote accountable the people who make minor mistakes. So the question really is, what's truly being protected, the badge or the comfort of avoiding the harder question? The Weyker case invites us to reflect on that very tension. Here was conduct that on the surface appears to serve a vital mission, protecting a witness in a very important investigation. Yet it resulted in a prolonged detention of an innocent teenager for 25 months. And the court ultimately concluded these actions fell under the federal authority, placing them beyond the reach of the claim. Yet, the episode leaves a deeper question lingering in the air. How does this person get to a place like that? Why does the internal machinery of accountability so often expend its greatest energy on the small and the visible, while the larger, more consequential failures of the industry, like officers stealing, illegally detaining citizens, breaking into evidence lockers, or using drugs that they confiscate, sometimes receive far less sustained scrutiny? It's not a matter of cynicism, it's a matter of human nature and the unconstitutional incentives. It's easier to target and always more tempting. The harder ones demand a discomfort of the agency, self-explanation, and the courage to confront genuine misconduct whenever it appears, whether on the street or inside the task force. Now, the issue here is it appears, based off of what's available in the research, that this person might have had a very troubling past as an officer. There have been multiple civil suits against this person, a lot of them alleging lying and misstatements, which diminish public trust and should be an issue. Command staff should carry a profound responsibility here. Public trust is not earned by parading minor deviations before the public as a proof of quote-unquote transparency. It's earned quietly and steadily by relentlessly pursuing the real failures and creating an environment where honest questions from within the ranks are welcome rather than punished, and by directing finite resources and energy towards the conduct that is actually threatening the integrity of the institution. In that choice lies the difference between mere appearance and genuine accountability. That brings us to the leadership navigational aid. There are no bad troops, just bad officers, an axiom as old as the profession of arms. Colonel David H. Hackworth delivered that blunt truth in Steal My Soldiers' Hearts, while he took command of a demoralized infantry battalion in Vietnam and forged it into a disciplined fighting force that refused to break. The single leadership principle this case illuminates is that strong institutions remain open to redress, honest questions, even from their own officers, because enduring problems are rarely the fault of the team itself, but often reflect conditions created by, permitted by, and endorsed by leadership. In Mohammed v. Weyker, the conduct of cross-deputizing an officer on a federal task force highlighted the gaps that can appear when a local and federal authority converge without clear lines and clear oversight. The court ultimately determined the officer acted in her federal capacity, which shielded her from the claim. And Hackworth's insight invites leaders to examine the underlying system rather than the individual actors alone. In this practice, it means establishing reliable channels for officers to raise concerns about task force operations, maintaining clear documentation for the source and authority in joint investigations, and ensuring that policies governing deputization reflect the constitutional realities of the dual role. In Mohamud's litigation, it teaches that when leadership owns the conditions that produce friction, agencies develop greater resilience, better decision making, and stronger public trust over time. Leaders carry the heavy responsibility of exercising authority with restraint and precision to protect both public safety and the constitutional rights. In the end, the institution that welcomes honest questions from within and without, and that directs their disciplinary energy towards real, serious misconduct rather than frivolous, low-level matters, which could easily be addressed with a conversation, are the ones that best position themselves to fulfill their mission with integrity. Now, looking ahead, the convergence of federal and local authority in these task force positions will only likely deepen. And as we've seen in recent months with things like shootings involving federal police officers, these threats cross jurisdictional lines and technology compresses time. Officers will continue to find themselves operating under these dual hats, sometimes unmarked vehicles or obscured identifications. The legal doctrine of the color of law will remain steady as the feature of the environment, requiring leaders to anticipate how courts will characterize the source of authority in any given operation. Now, training that emphasizes clear documentation of federal versus state roles, regular review of these cross-deputization MOUs, and the open channels for internal questions will become essential. Officers and administrators who approach these complexities with deliberate judgment and constitutional discipline will shape the weather rather than merely react to it. The work remains demanding, yet the institutions that maintain precise lines of accountability and welcome honest scrutiny are the ones that will endure with integrity. Now, as we close, let's remember, the point of this show is not to pass judgment or to revisit the decisions with the benefit of hindsight, even if it feels that way. It's to learn as a team and to improve. We're all leaders, so keep the L&A in the back of your mind. The work is complicated and the environment is demanding, and none of us get it right. So stay hungry, stay humble. I'm Don, and this has been the Conditions Report. And so we return to the quiet truth that Dostoevsky once gave us that I think fits perfectly in the constant pursuit of our professionalism. Pain and suffering are always inevitable for large intelligence and a deep heart. The great men must, I think, have great sadness on earth. The greatest happiness is to know the source of our unhappiness. In that knowledge, in that honest, uncomfortable self-reflection lies the path to real progress, both for ourselves and for the institutions we serve. Be the calm in the storm, clarity in confusion, and always influence the weather.